Good afternoon and good morning to all of you from all of us at the United States Copyright Office in Washington, D.C. My name is Miriam Lord. I'm Associate Registrar of Copyrights and Director of Public Information and Education here. My office is pleased to welcome you to today's webinar. We're so pleased to be joined by so many of you from all over the country. We saw a huge level of interest in this program with over 1,300 people registered. To me, this indicates a hunger for copyright information, which is wonderful. The copyright system is important to everyone, since everyone is a creator and a user of copyrighted works within the system every day. The Copyright Office has an overarching strategic goal of copyright for all. What does this mean? What it means is that we focus on making the copyright system as understandable and accessible to as many people as possible. We do this work through webinars like this new series, as well as through the distribution of web and print materials, as well as social media channels, availability of our staff to take questions, and outreach at all levels. So today, you'll hear from two members of my staff, attorney advisors, Laura Kaiser and Jessica Chinnadurai, as they walk you through copyright concepts that we are confident will be helpful for you in your work and your life. So I'm going to welcome Jessica and Laura to kick things off. Laura will help with some housekeeping and more details, and we'll just get right down to it. So thank you again for joining us. We look forward to your feedback. Thanks.
Thank you, Miriam. Good afternoon, everyone, and thank you for joining. We are thrilled that so many people want to learn about copyright. Before we get into our session, a few logistics for today. This event is being recorded and we'll post it to our event page once it's captioned, and the captions are enabled for today. There will also be a survey after this webinar. We develop programs like this with your feedback in mind, so please do fill out the survey if you have the time. We also have a public information office who you can contact if you have any questions that aren't answered by today's presentation, and we'll put the contact form into the chat for you. Today, we're going to start with a very brief overview of the Copyright Office. Then we'll talk about the basics of copyright law before getting into some common copyright myths. We will, of course, explain what the truth is, and we'll also be dropping links to some fantastic Copyright Office resources for you all, so please keep an eye out for those. So as Miriam mentioned, your presenters today are myself, Laura Kaiser, and my colleague, Jessica Chinnadurai. We are both attorney advisors in the Public Information and Education Division of the Copyright Office. We frequently participate in outreach projects to educate the public about copyright issues like this webinar, and we're both excited that you've joined us today. So the Copyright Office was founded in 1870, and we are a federal government agency that is part of the Library of Congress in Washington, D.C. So we are part of the legislative branch of government. And when we talk about the Copyright Office administering the Copyright Act, that's a pretty broad statement. It entails a number of different roles, and we're going to get into those later in the presentation. But for now, I'm going to turn it over to Jessica, who's going to set us up with some copyright law basics.
Thank you, Laura. So before we get into a discussion of today's copyright myths, we just wanted to ensure that our audience has a foundational understanding of copyright. Copyright law is found in Title 17 of the United States Code, also known as the Copyright Act, and the law itself states that copyright protects original works of authorship fixed in a tangible medium of expression. What this means is that we first must have a work of authorship, and that work must be fixed and original in order to be protected by copyright. A work of authorship is the subject matter protected by copyright. This includes literary works, musical works, including any accompanying words, dramatic works, including any accompanying music, pantomimes and choreography, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. Fixation is the next item here, and fixed basically means that the expression must be written, recorded, or otherwise captured in a copy, and must be sufficiently permanent or stable to be perceived, reproduced, or otherwise communicated for more than a transitory duration. The key here is that the moment a work is fixed is the moment that copyright protection begins. Lastly here, originality in copyright involves two separate components. The first is what we call independent creation, and the second is sufficient creativity. Starting first with independent creation, that means that the work must be independently created by the author, meaning that the work must originate from the author and not be copied from another work. In theory, two works could be the same or similar and each be subject to copyright protection, so long as the similarities are just by chance and not a result of direct copying. That second component, sufficient creativity, requires that the work contains at least a small amount of creative expression, but that small amount does have to be more than trivial. For example, words and short phrases, familiar symbols and designs, including common geometric shapes, and typeface or lettering are not protected by copyright because they are not sufficiently creative. That's a great point to end on here and help us transition to our first myth. So when people ask me where I work and I say at the US Copyright Office, the response I'm often met with is, "Oh wow, my cousin created this cool new invention," or "My friend was recently talking to me about their catchy business name." We're starting our discussion of myths today with one that we hear too often. Your business name or new invention are protectable by copyright. And if we stop to ask ourselves, why is this a myth to begin with? It's not uncommon for copyright to be mentioned, maybe even in the same breath as trademarks or patents. All three fall under a larger umbrella of law called intellectual property, or IP for short, and IP refers generally to creations of the mind. Some IP is even mentioned in the Constitution, specifically copyrights and patents. In Article 1, Section 8 of the US Constitution, Congress is granted the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So given all of this overlap, what is the truth about business names and new inventions?
The truth is your business name or new invention are not protectable by copyright, but they may be protected by patent or trademark law. And that's because business names, slogans, and logos are protected under trademark law, while new inventions are protectable under patent law. And as Jessica explained, these areas of law fall under the larger umbrella of intellectual property or IP rights. But it is important to remember they are separate areas of law. So to expand on that, trademarks identify the source of goods and services. For example, a brand name, tagline, logo, or product configuration that help consumers identify the source of what they're buying or using. Patents protect new inventive ideas, for example, inventions, discoveries, processes, methods, or machines and devices. And copyright protects creative expression fixed in a tangible form. So for example, paintings, photographs, novels, films, musical works, and sound recordings. The U.S. Patent and Trademark Office handles trademarks, and patents, and the Copyright Office administers copyright law. So this is our first resource corner for today. Throughout this presentation, we are going to highlight several of our fantastic resources so you can see the wide array of what we offer. The first resource is a collection of web pages that encourage you to engage your creativity, and we'll put the main landing page in the chat now. From this landing page, you can navigate to separate Engage web pages that highlight a collection of resources for specific creators. For example, the web page shown here, What Visual and Graphic Artists Should Know About Copyright, provides resources for visual artists, while also discussing how simple stylized logos or minimalist art are not protected by copyright, but might be protectable by trademark. And at the bottom of the webpage, there are additional resources for this group of artists, including a relevant handout. There are similar Engage web pages for musicians, photographers, and writers, and the office will continue to update and add to these collections. Now let's go on to our next myth.
Sure. So the second myth that we have is the common misunderstanding that because you paid someone to create something for you, maybe artwork for your website or a foreword for your novel, that you now own that expression. Why this might be a myth to begin with is likely because of a misunderstanding of copyright ownership. Specifically, ownership of a physical item, such as a book, is different than ownership in the copyright for that book. And without this knowledge, it might be easy to connect the dots in a way that results in thinking that because something is in your possession, that it's yours. But Laura, what's the truth about copyright ownership, and what does it mean if someone's paid for creative content?
So the truth is, in general, the creator of a work or the author is the copyright owner. In copyright law, to be an owner, you must be the author of the work. But who is an author? An author is usually the work's creator, but there are exceptions. In the case of works made for hire, the author would be an employer or the commissioning party. We're going to discuss the two categories of works made for hire in just a moment, but it is important to know that just paying someone to create something does not determine ownership of the copyright. Similarly, simply owning the physical work, such as a painting or a novel, does not necessarily mean that you own the copyright in that item. So works made for hire include works that were created by an employee as part of that employee's regular duties. So when considering whether a work was created as part of an employee's regular duties, some questions to consider include the following. What skill was required to create the work? Where was the work created? Did the employer provide the space, materials, and tools to create the work? How long the relationship was between the parties? Could the employer direct the creator when and how long to work? How was the creator paid? And was the work created as part of the creator's usual tasks or during their authorized work time? Works made for hire can also include works that were created as a result of an express written agreement between a creator and a party specially ordering or commissioning the work. A specially ordered or commissioned work is considered a work made for hire if certain criteria are met. We won't go into detail about that today, but in general, the work must fall into one of 9 categories mentioned in the Copyright Act. For example, a contribution to a collective work, part of a motion picture or other audiovisual work, or a translation. There must also be a written agreement between the party that ordered or commissioned the work and the individual who actually created the work. And in the written agreement, the parties must expressly agree that the work is to be considered a work made for hire. So that means that the phrasing work made for hire must be used. And finally, the agreement must be signed by all parties. If the work is a work made for hire, the employer or the commissioning party is considered the author and therefore the copyright owner. Again, our myth here had to do with paying someone to create something for you. And as you can tell, none of what we mentioned here in the truth involves the payment. Here's another resources corner for you. The office circulars provide up-to-date and authoritative information on copyright law, policies and procedures, and registration issues. We have a number of circulars covering the basics and fundamental concept of copyright law, office practices and procedures, copyright concepts, licensing, and registration issues for specific categories of work, including visual artworks, performing artworks, and literary works. We'll drop the link to the general circular page into the chat, but we also want to take a minute to highlight a circular that's dedicated to works made for hire. That's Circular 30, and we'll make sure that you have the link in the chat to that specific circular as well. There is a very helpful questionnaire in Circular 30 that can help you determine whether or not a work is a work made for hire. When you're submitting a work for registration, whether or not the work is a work made for hire is a question on the registration application that you as the applicant must answer. And importantly, the office cannot make this determination or answer the question for you. So the questionnaire is a great resource to help you in your decision-making. For example, the first question asks, was the work created by an employee? If the answer is yes, you proceed to question 2. And if the answer is no, you proceed to question 3 and so on. And at the end of the questionnaire, you should arrive at an answer on whether a work is a work made for hire. So with that, we are ready for our next myth. Our next myth focuses on ownership. Isn't owning a copyright just about preventing others from making copies of my work? When someone sees the word copyright, they might just think about the copy part and jump to the conclusion that it's the only right involved with copyright ownership. But Jessica, What's the truth here?
The truth is copyright owners have 6 exclusive rights in their work. Just one is what we call reproducing or making copies of the work. You might have heard of these rights referred to collectively as a bundle of rights, and there are 6 total, including the right to reproduce or make copies of the work, prepare derivative works such as adaptations, remixes, or translations. Copyright owners also have the right to distribute copies to the public by sale, transfer of ownership, rental, lease, or lending. And then for certain works, the right to perform or display the work publicly. Additionally, the copyright owner of a sound recording has the right to perform the sound recording publicly by means of digital audio transmission. Copyright owners can actually engage in any one of these rights, and they can also authorize others to take the action that the right provides. Copyright infringement generally happens when any one of these rights is violated, and that just means that someone is not authorized to take an action listed here. So for our next resource corner, the office has a great video on exclusive rights that you can find in our Learning Engine video series on YouTube. The entire series right now contains about 23 videos covering a variety of topics like fair use and the public domain, as well as the history of copyright law and the office. The link to our Learning Engine videos on YouTube is being provided in the chat now. And a general note on YouTube, the office has several playlists available for viewing on our channel, including one on copyright and artificial intelligence, and others on the Music Modernization Act, as well as our modernization efforts internally at the office, which include the bi-monthly recorded webinars that we host to discuss modernization within the office.
So while we're on the subject of the exclusive rights, let's also talk about responsible copyright use. Our next myth is related to that. If something is on the internet, I can use it for free and without asking permission. There's a ton of content on the internet these days, and some of it isn't behind a paywall, so anyone can access it. That access alone might lead someone to assume that content is free to use, or that the content's creator gave them implied permission by simply posting their work online to begin with. There are also various disclaimers used online, such as no copyright infringement intended, or this is fair use, or images are believed to be in the public domain. Jessica, can you help with the truth here?
Sure, just starting with the truth itself. Just because something is on the internet does not make it free to use without the copyright owner's permission. There are several important considerations that the office wants to highlight today to encourage responsible copyright use, especially in an increasingly digital world. First, understanding disclaimers is important. When, as Laura mentioned, you read a blog including a found photograph and the photo credit reads, "This is fair use," take a moment to think about that statement. Fair use is a legal doctrine that promotes freedom of expression by permitting an unlicensed use of copyright-protected works in certain circumstances. The Copyright Act itself does include a list of activities that may qualify as fair use, including criticism, comment, news reporting, teaching, scholarship, and research. However, a court evaluates fair use on a case-by-case basis, and the outcome of any case depends on a fact-specific inquiry. This just means that there is no formula to ensure that a percentage of material, such as a specific number of words, lines, or pages, can be used without a copyright owner's permission. Other than disclaimers, it's important to consider that there is no implied license to use content just because it's been shared online. So requesting an express license is an important consideration for responsible copyright use, and something that you can do alone or with the help of an attorney. The same can be said of asking a copyright owner for permission to use their work. And lastly here, a responsible copyright user might also consider using public domain material. The public domain is not a place, which is another common misconception, but a work of authorship is in the public domain if it is no longer under copyright protection or if it failed to meet the requirements for copyright protection. So for our next resource corner here, the office has no shortage of information to help you be a responsible copyright user. No matter where you found your work, including if it was on the internet, if you intend to use material that you did not create, it's a good idea to first determine its copyright status. That means whether or not the copyright term has expired, and if not, who the copyright owner is. So while the office cannot grant you permission to use a work, you can start your research into the copyright status of a work by searching the records that the office maintains. So we'll start first with the official online public catalog, which we'll share a link to in the chat now. This contains records of copyright registrations and transfers of copyright ownership created between January 1st, 1978 and the present. And then pre-1978 records, that is records created between 1870 and 1977, are searchable on-site in the Copyright Office in Washington, D.C. This card catalog has also been digitized, and it's in a proof of concept virtual card catalog. And then in exciting news, searchable card catalog records are also included in our new Copyright Public Records System. The acronym here is CPRS, and we'll share the link to CPRS in our chat now. CPRS is in its pilot, but the office continues to develop it so that users have a single, easy to navigate and highly searchable database of Copyright Office public records. The pilot does not replace the official online public catalog, that first link we shared, but it's another great tool to use when researching the copyright status of a work that you're interested in using. And when accessing CPRS, you can try out both the simple search interface and the advanced search interface that includes a query builder and filters. Please also note here that your feedback on the system's functionality and features is really crucial to improving and enhancing the CPRS pilot. So you can provide feedback on your experience by using the feedback link at the bottom of the webpage provided.
So as we think about the public record for copyright ownership in the public domain, a common question is, how long does copyright last? Some may think that copyright lasts forever. Copyright duration has changed over the years. For example, the first federal copyright law in 1790 protected registered works for 14 years with a 14-year renewal option. And then in the 1800s, the first term increased to 28 years, and there was still an option to renew copyright for an additional 14 years. Under the 1909 Act, the copyright term was set at 56 years. So under the current copyright law, the Copyright Act of 1976, what's the truth about copyright duration today?
The truth is that the term of copyright, meaning how long it lasts, depends on who the author is. But in general, the copyright term is limited. And before we get into today's copyright law, we can take another look back at the language provided in the Constitution's Copyright Clause, Article 1, Section 8. The language from the clause says that copyright's purpose is to promote the progress of science by securing exclusive rights to the author's writings for limited times. So essentially, it would be unconstitutional for copyright to last forever. Copyright law today provides a current term of copyright protection that lasts for the life of an author plus an additional 70 years. In the case of works made for hire, anonymous, and pseudonymous works, copyright lasts for 95 years from the work's first publication or 120 years from the work's creation. Whichever is shorter, that just means whichever expires first. As Laura discussed earlier, the author of a work made for hire is the employer or the commissioning party, but you might be wondering here what anonymous and pseudonymous works are. So an anonymous work in copyright law is one on which no natural person is identified as author. That just means that on the work itself, no person is named nor identified. As for a pseudonymous work, that is a work on which the author is identified under a fictitious name. This is another common misunderstanding in copyright law that we hear a lot. For example, that an abbreviated name or nickname is a pseudonym. But in copyright law, a pseudonym is a completely fictitious name that an individual author can use to identify themselves to the public. For example, the British writer J.K. Rowling's full name is Joanne Rowling, so she's using an abbreviated name there, J.K. Rowling, and then she does use a pseudonym you might have heard of, Robert Galbraith. When an author places their pseudonym on copies of their work instead of using their real name, the work may be considered a pseudonymous work under copyright law and then may be afforded a longer term of protection that you see here on the slide. Importantly, though, when copyright protection ends or its term expires, a work enters the public domain. And to expand on the public domain in our next resource corner, once copyright protection ends, the exclusive rights of a copyright owner no longer exist. What this means is that the work can be reproduced without permission, it can be performed or displayed publicly, and it could also be used in the creation of new works, such as adaptations and translations. As you can likely tell, the public domain has important historical and cultural benefits in the life cycle of copyright. So for our next resource here, we're highlighting our public domain blog post, which is on the office's official blog titled Creativity at Work. And while the office does not compile, nor do we maintain a list of all works entering the public domain, each year the office does publish a blog post highlighting some of the works entering the public domain in January of that given year. So this year we highlighted a number of works published in 1928, which entered the public domain in 2024. And this post and others on our blog can be read at the link in our chat.
So switching gears, let's talk about myths related to copyright registration. The first one is the myth that to protect a work, you need to register it with the Copyright Office. And here, the confusion might stem from what we mentioned earlier regarding the other areas of IP. For example, to obtain a patent, you need the government to review and approve a patent application to secure your rights. So what's the truth about copyright registration?
The truth is that no formalities are required to secure copyright protection today. This means a registration application does not need to be approved by our office, nor do any special symbols or notations have to be put on your work. Under older copyright law, it used to be true that the copyright notice, that's the C in the circle you've probably seen, or the abbreviation COPR, that notice had to be used on a work in order to secure copyright protection. But under the current copyright law, this notice is now optional for works created after March of 1989. The key point under today's law is that works are protected by copyright as soon as an original work of authorship is fixed. That's the moment that copyright protection begins. So you might be asking yourself, why would you register your works then? While it's true that registration with the Copyright Office is not required, it is recommended. And if you want to register your works, the Copyright Office in the United States is the only place that you can do so. We run the nation's only copyright registration system. There are a number of benefits to copyright registration that we wanted to be sure to mention. A few relate to the public records that we were just discussing. So for example, when you register your work with the office creates a public record that includes key facts about the work, who the author and owner is, the title of the work, and if published, in what year and what country first publication occurred. In this way, the public record contributes to the public record of creativity. Our records, again, might reflect that a work is in the public domain, which allows others to make copies of or prepare derivative works based on that original work, and that fuels creativity. Registration also helps potential licensees or people and entities interested in obtaining your permission to use your work to find your contact information and get in touch with you. Additionally, another benefit of copyright registration is that it opens the door to enforcing your copyright. And what we mean by enforcing here is pursuing a copyright infringement lawsuit or claim. If a copyright owner's exclusive rights have been violated and they want to file a copyright infringement lawsuit in federal court, then the office must have issued a registration decision, meaning we either approved or refused registration for your work. A registration application also needs to be approved by the office in order for the Copyright Claims Board, which is an alternative to federal court, in order for the board to issue a determination. So the office's FAQs are another great resource for you, and they cover a variety of topics, including copyright registration. Under the larger menu option that you see selected here called Registering a Work, some of the FAQs include answers to the questions, how do I register my work, and where can I even get application forms? Other menu options here include who can register and which form should I use. So the link to our general FAQs is being provided in the chat now. Additionally, when submitting an online application and navigating ECO, that's the Electronic Copyright Office Registration System, There are separate FAQs that address how to register claim in ECO, how to upload your electronic files, and information about payment. So there's a separate link for the ECO FAQs being provided in the chat now. Staying on the topic of copyright registration, our next myth is that you cannot file a copyright registration application without a lawyer. We've talked a lot today already about copyright law, and the registration process does require that you meet certain legal and formal requirements. So it might be easy to assume that copyright registration is a very complex process that involves a lot of legal jargon that's difficult to decipher, or maybe complicated hoops that you have to jump through. But Laura, what's the truth about the registration process?
The truth is that in most cases, you can file your own registration application. It may be helpful to consult a legal advisor, but the office also provides many resources to support you during the registration process. We've discussed some of those resources already, and we'll discuss more in just a minute with our next resource corner. But in terms of the registration process itself, we do want to provide some clarity around the expense and the timing of the registration process, and it might make it seem less complex or overwhelming. First, let's start with the expenses. Applications can be submitted online using ECO, and the fee you pay will depend on the number and type of works you're trying to register. The general rule is that you must submit one work with one application, and our most inexpensive form there is $45. However, the office also has created a number of group registration options that allow you to submit more than one work on one application. Most of the group options are required to be submitted online, and those applications range in cost from $55 to $85, depending on the type of work you're submitting. The office also provides paper forms if you're interested or need to submit a registration application in the mail. And the most inexpensive paper form requires a $125 fee. And in terms of how long registration takes, generally it takes only a month and a half. The office frequently posts its registration processing times on our website, copyright.gov, and some of those details are summarized on this slide. So for an online application with an electronic copy of the work, the processing time is averaging 1.4 months. That's as of the end of September of 2023, when no communication was required with the applicant. So that's what the words "no correspondence" here mean. And when the office did need to communicate with the applicant, the average time to process increases slightly to just 3.5 months. In general, an application submitted using a paper form is taking about 4.1 months to process, again, when no correspondence was needed, no communication with the applicant. So our office provides many different types of guidance to the public on the registration process, including many of the resources we already mentioned today, our circulars, our Engage Your Creativity web pages, and our Learning Engine videos. But we also have resources that are dedicated just to registration, including a main homepage. So we've highlighted our registration tutorials to start, which is what you can see on the tablet here. ECO, again, that's the abbreviation for the office's electronic registration system, is used to submit an application for different types of works and registrations. The tutorials provide a visual walkthrough of ECO. For example, the first slide in the tutorial on a standard or single application shows you what the ECO homepage looks like, so it's clear how you can navigate to the application you want to use. We'll put the link to the tutorial videos in the chat now. But registration help can also be provided live during a walkthrough appointment. A walkthrough appointment is a service where a Copyright Office staff member assists you in navigating an electronic registration application. They'll explain the application screens and the types of information that are required. You can schedule a walkthrough for one application, and those are all over the phone and are 30-minute appointments. Please just note it does take a few days to process those requests, but the appointment times are available Monday through Friday, 8:30 a.m. to 5 p.m., and the last appointment starts at 4:30. If you have a question during the appointment, the staff member conducting your walkthrough can't provide legal advice, but they may be able to provide resources or additional context. The link to our online form where you can submit a walkthrough request is in the chat now. And with that, we are on to our next myth.
Great. So moving away from registration for just a minute and thinking about enforcement. Our next myth is that I can only enforce my copyrights in a federal court. This misunderstanding might exist just because a few years ago, federal court was the only avenue to get judicial resolution of copyright disputes, including for all copyright matters, regardless of size, and for all parties, including copyright owners and users. But what happened a couple of years ago that changed this?
So back at the end of 2020, Congress passed the Copyright Alternative in Small Claims Enforcement Act, also called the CASE Act, and that established the Copyright Claims Board. The Copyright Office then began the process of setting up the board. It's also called the CCB. And in June 2022, the CCB opened its doors to hear claims. So the truth, in short, is that the CCB is a streamlined alternative to federal court to resolve certain copyright disputes. According to the CASE Act, the CCB can hear copyright disputes involving claims up to $30,000. And the CCB hears 3 types of claims: claims for copyright infringement, claims for a declaration of non-infringement, and claims brought under Section 512F of the Digital Millennium Copyright Act for misrepresentation. In the CCB, the person or entity bringing the claim initially is called the claimant, and the person or entity that the claim is being brought against is called the respondent. Importantly, this is a voluntary forum, so respondents have an opportunity to opt out of the CCB, which means the case will be dismissed, but the claimant then has the option to bring the claim in federal court. Copyright infringement claims can be brought by legal or beneficial owners of the exclusive rights at issue in a dispute about whether one or more of the copyright owner's rights were infringed. For a claim seeking a declaration of non-infringement, the CCB could issue a determination that the claimant's actions or potential actions do not infringe on the respondent's copyright. A 512F misrepresentation claim specifically deals with the actions of the parties and online service providers in the notice and takedown process set up in the Digital Millennium Copyright Act. Online service providers include websites that host content uploaded by users, such as YouTube and Instagram, and search engines that direct users to particular websites, such as Google and Bing. So if you're looking for more information on the 3 types of claims we just discussed and how to navigate the Copyright Claims Board in general, the CCB Handbook is a great resource. We'll drop the link in the chat now to the handbook, and this is the practice manual for the CCB. The handbook has over 20 chapters and provides an in-depth and authoritative resource for filing, responding to and opting out of claims, seeking assistance with your claim, and more. For example, there are chapters specifically regarding how to start each of the 3 claims we went over, and there are chapters related to service, discovery, settlement, and how to present your case. So we encourage you to check out this great resource and the CCB's website, ccb.gov, if you are a potential CCB participant or if you would just like to learn more. Our audience may have seen the office in the news recently regarding copyright and artificial intelligence, particularly related to the registration of works containing AI-generated material. And looking at the numbers around registration, our staff examines hundreds of thousands of copyright claims per year, resulting in an average of over 500,000 registrations annually. That's a lot. So the office is only involved in registration, right?
Not right. That is a myth. And the truth is that the office has several important duties that help fulfill copyright's constitutional purpose. Our mission statement is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial expert advice on copyright policy for the benefit of all. We mentioned at the beginning that administering copyright law is a very broad statement, so we're clarifying here what all that entails. Our small but mighty staff of about 450 employees is responsible for many things. First, we make and maintain records that provide details on copyright ownership. That certainly includes the registration component we've already covered, as well as recorded documents about transfers of ownership. The office also administers statutory licenses and helps to manage and distribute royalties as required by law. Congress has also delegated authority to the Copyright Office to develop regulations, and these regulations concern many areas of copyright law. The subjects cover a wide range of topics, including rules governing submissions to our office, such as the different types of copyright applications, fees paid for the office's services, and then filings related to statutory licenses, FOIA requests, and more. These regulations provide the public with a well-functioning copyright system overall. The office also advises Congress on national and international copyright matters, which includes the Register, the head of the agency, testifying upon request, and providing ongoing impartial expertise on copyright law and policy. The past few years have been particularly active as office lawyers have assisted Congress with copyright review hearings and prepared numerous policy reports. Similarly, we work with government colleagues to deliver critical domestic and international policy analysis and advice. For example, we participate on U.S. delegations to international meetings and provide counsel to the courts when significant copyright questions arise in litigation. And then last but not least here, we provide authoritative copyright information to the public by answering questions and developing educational programs. For example, all of the great resources that we've highlighted here today that explain copyright are developed, maintained, and updated by our staff. So the biggest takeaway for you all here today, the most important resource that we want you to remember is our dedicated website, copyright.gov. You might come across other websites claiming to be the Copyright Office, but the .gov here is an important identifier for you. That indicates it's a federal government website with authoritative information. We certainly hope and encourage you to explore copyright.gov to find additional resources that we might not have covered today.
So our final myth for today, copyright does not affect me. This might be due to copyright being overgeneralized. So for example, maybe you've only read about or seen famous musicians or singers involved in legal battles over copyright. Or maybe you've seen copyright mentioned in a movie's end credits or on the title page of a book that you're reading. But Jessica, what is the reality here?
So the truth is, copyright affects everyone. We are all copyright owners and users. And the examples that Laura just provided in music, movies, and books might make it easy to overgeneralize copyright and think of it as only siloed into literary works, visual artworks, and performing artworks. But if you take a look at more specific examples of materials protected by copyright, you'll quickly realize how copyright surrounds us in our daily lives, even if you don't consider yourself a creative person. So for example, in the category of performing arts, works protectable by copyright might include dramatic works like plays and operas, sound recordings, which includes podcasts and audiobooks, musical works, including their lyrics, and choreography. Motion pictures include audiovisual works, which encompasses TV shows and video games. And if you're a small business owner, maybe you create videos explaining the products that you sell or the services that you provide. That content falls under this category as well. Visual artworks might include paintings, drawings, and photography, but this category also captures sculptures, jewelry, and architectural designs. Again, if you're a small business owner, this might look like artwork in your logo, product label, or your advertising materials. And then lastly here, literary works are not just books and newspapers. They also include magazines, computer programs, blog posts, and many more items we haven't listed today. So the World Intellectual Property Organization, or WIPO, commonly refers to the core copyright industries as those who have a primary goal to create, produce, distribute, or display copyright materials. And in a recent WIPO report on copyright industries in the United States economy, they said the value added by the core copyright industries to US GDP reached more than $1.8 trillion and employed over 9 million workers. With those numbers, which have increased over the years, the importance of copyright simply cannot be overlooked. So we'll end here with our last resource corner. And in the welcoming remarks for today's webinar, we mentioned the office's strategic plan, specifically the goal of copyright for all. But this goal and the entire strategic plan shine a light on copyright's increasing relevance to society. As part of our effort to expand our outreach and education programs and grow awareness of copyright and its benefits, the Copyright for All goal in particular aims to make copyright as understandable and accessible as possible to everyone, from individuals to businesses of all sizes. And one key element of this is reaching out to underserved communities and bringing people into the copyright system who may not have been aware of it in the past. As for the other 3 goals that you can find in the strategic plan, which we will drop a link to in the chat now, that includes continuous development, which is our commitment to improving and updating our services, including making technology robust and offering flexible services. Then the goal of impartial expertise means that the office will continue to provide expert advice on copyright law and policy to Congress, the courts, and other agencies, both domestically and internationally. And then lastly, the goal of enhanced use of data means we're enhancing the use of data as a decision-making and performance measurement tool, and making that data available to stakeholders who can help advance copyright knowledge. So that was our final myth, and I have the pleasure of turning the floor back to Laura, who will provide some closing remarks. Thank you so much, Laura.
Thanks, Jessica, and thank you all for joining us today. We highlighted many office resources today, including the Copyright Office circulars, learning engine videos on YouTube, registration tutorials, the Copyright Public Record System, our FAQs, our Engage Your Creativity web pages, and all of that's available on our website. Again, that's copyright.gov. For updates from the office, you can also subscribe to our Newsnet. That's our digital newsletter, and we'll drop that link in the chat so you can subscribe to that and other Copyright Office subscriptions, our blog, event updates, and legislative developments. We also encourage you to follow us on X and LinkedIn. So thank you again for attending. A survey is going to be sent out to attendees. We welcome and appreciate your feedback on today's webinar. If you'd like to request a speaker from the office, you can complete a speaker request form, and we'll drop the link into the chat for that. And again, if you have follow-up questions from today's presentation, please feel free to reach out to our public information office using our contact form. Our office can also be reached by email and phone, and we'll put that information in the chat as well. So thank you so much again for attending today.